This podcast is brought to you by the School of Advanced Study, University of London. All of our podcasts are available from our website, www.sas.ac.uk.
Okay, well, a very good evening to everybody. And thank you to you all for joining us on what is a cold and wintry November evening. I'm very, very pleased this evening to be able to welcome an especially distinguished speaker to our seminar series on international refugee law. It's my very great pleasure to be able to welcome Mr. Justice Blake, President of the Upper Tribunal, Asylum and Immigration Chamber of the United Kingdom, who will be addressing us this evening on international standards and national application, asylum decision-making in the United Kingdom, Strasbourg and Luxembourg. I suspect that Mr. Justice Blake's name will be known to the great majority of you here. Nonetheless, I think it's worth introducing a few of the distinguished features of his long career in asylum and human rights law. Mr. Justice Blake was called to the bar in 1974 and has been practicing since then on issues of social assistance law, miscarriages of justice, immigration, asylum and other related questions of public law. This led to his appointment as Queen's Counsel in 1994, and in that capacity he argued a great number of leading cases on both refugee law and human rights law. Previously at two Garden Court, he was in 2000 a founder member and the first chair of the well-known Matrix Chambers in London, and in 2007 was appointed to the High Court of Justice, Queen's Bench Division. More recently, in 2010, Mr. Justice Blake was appointed as the first president of the newly created Immigration and Asylum Chamber of the United Kingdom Upper Tribunal. And alongside his many engagements as a practitioner, he's also found time to publish and edit a great number of volumes, including the MacDonald Immigration Law and Practice, the leading textbook in this field. So it's with very great pleasure that I turn over to our speaker for this evening and give them a warm welcome to the Refugee Law Initiative.
Thank you for the introduction. Thank you for the invitation. A long time ago, which in refugee law means 1975, there was the Refugee Convention somewhere out there. The New York Protocol, comparatively recently bringing refugee law alive for the latter half of the 20th century. It wasn't inscribed in any of our statutes. There was a faint reference to it in the immigration rules, and there was a mismatch between procedure. But most of all, no one had any idea what it meant. That's when I started practice in this field, and if in doubt on questions of persecution, I would turn to the Oxford English Dictionary. There was one difficult to obtain textbook by a scholar from the 1950s, Grell Madsen. The second volume was never obtainable unless you happened to have a secret pass to the inner vaults of the most secret library in the United Kingdom. And that's how things developed. Gradually, we began to learn about the Refugee Convention. Then scholars, particularly James Hathaway, started to write about the topic on the Canadian experience, and we grew. Alongside the Refugee Convention, with its well-known definition of refugee, a person who has a well-founded fear of persecution for reasons of race, religion, political opinion, membership of a particular social group, and is outside their country, and is unable or unwilling to return there. There have developed other provisions of protection, which I will include, I do include, within the umbrella of protection law, because this is the daily bread of the immigration judiciary today. Right from the beginning, there was Article 3 of the European Convention of Human Rights in Strasbourg, but it was only late in the day, in the 1980s and 1990s, that it was recognised that an expulsion decision, a decision to send someone out from the United Kingdom, could engage the responsibility of the United Kingdom if the consequence of the expulsion was to expose someone to inhuman or degrading treatment abroad. We also learned from the Judicial decision that that is an absolute obligation. Convention, contrary to the Refugee Convention, drafted about the same time, which has an exception for people who are convicted of a particularly serious offence or considered a danger to the host community. But Strasbourg tend to, in these early days, to be very cautious about the application of Article 3, requiring substantial grounds for believing in an individual who is subject to persecution. That was spelled out in the case of Bilbaraja, a Tamil case, where on the application of the test, the claimants lost in 1991, even though, sadly for them, they were precisely tortured and ill-treated and returned to Sri Lanka, as they alleged they would be, before the administrative court, which couldn't really get down to the facts and the law. In more recent years, let's fast forward now to 2005, refugee law has grown in huge numbers, from a trickle of a few cases in 1975 to something like 60,000 in the height of the 90s, and now about 25,000 a year. And a judge at the national level in the United Kingdom has to examine a protection claim under a variety of heads. We have the Refugee Convention, and the rules and the statute now say expulsion decisions must not contravene the Refugee Convention. And the Refugee Convention means the Refugee Convention as interpreted by national law judges. We then interpolate the new boy on the block, the European Union's engagement in this topic. As always with the European Union, it started off the wrong way around. It started off with the provisions which said that if someone arrived in the United Kingdom, you could send them off to somewhere else in the European Union if they touched base there first, and they should determine their asylum claim. They never quite agreed what asylum claim meant or what the common standards were. So then you had problems to say, well, I can't send X to France because France doesn't apply the Refugee Convention. It applies a French concept, which is very good for France, but it's not what we think of the Refugee Convention. And we had the House of Lords telling us that there has to be a common understanding of the Refugee Convention. So, kicked into touch by this, the European Union then came up with something called the Qualification Directive, which is minimum standards in 2004, in effect in 2006, binding on all member states of the European Union. And the Qualification Directive gives guidance for minimum standards, and I stress that word, to interpret what the Refugee Convention means. And amongst other things, it meant France and Germany had to introduce into their legal thinking the concept of non-state agents of persecution, previously lacking. The United Kingdom had got there through common law interpretation, particularly using the Canadian and North American experience. And the Qualification Directive therefore says if you're a refugee, applying these criteria, you must be given a certain status and certain documentation, and there we are. But it also makes provision for something called subsidiary protection. And it's Article 15 of the Qualification Directive that's the interesting area. Article 15A talks about people who are facing a threat to their life, execution, capital punishment, or that's prohibited under the Strasbourg Convention. Article 15B talks about people who face torture, inhuman or degrading treatment, which looks very similar to Article 3 of the European Convention. Similar, but it's not the same. And it's important to note it's not the same. And people who say it's the same are wrong, because the Qualification Directive, like refugee status, is subject to a derogation for people who are considered to be a threat to national security or have committed particularly serious offences. Strasbourg, not the case. And 15C has a new concept with appalling language in Euro-German, contradictory, difficult to grasp, but it talks about the existence of a serious and individual threat to the life of a person in general conditions of armed conflict. So you have two opposing concepts. General conditions of armed conflict, whether internal armed conflict or international armed conflict, which create an individual and serious threat. And in a leading case called El Gefaji, Strasbourg, the Luxembourg court clarified that that could apply to anybody in a zone of armed conflict. It wasn't that you were walking around with a little cross on your head saying, I'm particularly vulnerable to attack or something, which is what tended to be the case for refugee persecution. So it could generally apply, particularly in areas of armed conflict, Iraq, Afghanistan, elsewhere. So you've now got these three levels of protection, three areas of protection, simplifying it all. You might have some fourth as well, but simplifying it to these. Refugee Convention, persecution through a convention reason, Qualification Directive, particularly serious individual threat in conditions of armed conflict of general application, and thirdly, Article 3 protection, exposure to human treatment. What's then happened is there's been a bit of a competition between Strasbourg and Luxembourg, which the national judge looks at with interest, scratches his or her head from time to time, and in 2008, the Strasbourg Court of Human Rights, the European Court of Human Rights in Strasbourg, said, well, we previously said you've usually got to have an individual threat before we'll grant protection, but we don't exclude the possibility in conditions of generalized oppressive behavior by states or non-state agents that a whole section of the population could be subjected to a real risk of torture or inhuman or degrading treatment in return, irrespective of their narrative, their credibility of their narrative, their individual circumstances, or their individual histories. And that was the case of NA in the United Kingdom, which was the Tamil case. So actually, it only took 17 years for them to essentially reopen the area where they decided to build Raja. I happen to be the councillor of Raja, so I knew quite a lot about it. And then, in 2011, Luxembourg dealt with a case called Sufi and Elmi. Let me tell you briefly about that, because that sets up the theme of my paper. This is the case from Somalia, an extremely unhappy country without a recognised government ever since President Barre was deposed in the early 90s. It's given rise to a great many difficulties as to whether people fleeing conflict and oppression and inhuman treatment in Somalia are refugees or entitled to subsidiary protection or whatever. Sufi and Elmi concerned people who had committed pretty serious criminal offences in this country, so there was every legitimate reason to want to get rid of them. But it wasn't possible to expel them if, on return to Mogadishu, they would face inhuman or degrading treatment. They went through the national system, then the Asylum and Immigration Tribunal, the AIT, and on the particular facts of assessment of risk, they lost. It was considered that there was a possibility for them to be returned to their clans in Somalia, where they could receive sufficient protection against torture or inhuman treatment. They then, in 2007, petitioned Strasbourg, and Strasbourg asked the British government not to expel them whilst they considered the case. It took 4 years for Strasbourg to consider the case, which is the problem. It took 4 years because they were waiting for the court in Luxembourg to decide the El Ghafarji case as to the scope of Article 15C protection I just mentioned. And Luxembourg was waiting for national courts to process one or two other cases as well. And so there was a sort of after-you system. Strasbourg likes to think of itself as the peak of the system and would like the national court to have delivered its judgment. Eventually, in June 2011, Strasbourg, having waited this 4 years, delivers a wide-ranging judgment based upon country assessment of problems in Mogadishu, and concluded at a particular time the group Al-Shabaab was operating to advantageous effect for people returning from the United Kingdom, and therefore there was a real risk that people would fall into their hands, therefore return was prohibited, therefore the claimants won. The next month, we had been waiting for Strasbourg for about 2 years, my colleagues in the upper tribunal gave a country guidance case on exactly the same issues in AMM, and we'd found already the picture had moved on, and we'd also found that in some respects Strasbourg's the weight given to Strasbourg, or the lack of weight given to Strasbourg's asylum information was flawed, and that we were prepared to give it more weight, although we reached the same conclusions overall. That is the background to this paper, which concerns about the country guidance system in the United Kingdom and elsewhere. Strasbourg is now developing a concept of lead case. Sufi and Elmi, NA the UK, Sheikh Salah the Netherlands, which is also a Somalia case, and one or two others. Cases where they think there are quite a large number of potential applicants falling within the scope, and they're waiting to give a lead case on Iraq, whether someone can be returned to Iraq, or parts of Iraq, northern Iraq, the Kirkuk governments. But they want the national courts to decide the issues first and then supervise it. There's a tension between whether Strasbourg are usurping the role of the national court by being the primary fact finder, or are playing the subordinate role of seeing whether the national court has done what it needs to do in terms of intensity and investigation of the conditions. These issues have become important because I'm going to suggest to you that although in the last decade refugee law, as developed in the United Kingdom, has been largely developed in the senior courts, the Supreme Court, the House of Lords, and some sort of Court of Appeal, teasing out concepts. Think of cases like Shah and Islam, the case of Adana Neitzinger, which talked about a proper international medium refugee convention. Fauna, dealing with gender persecution. HJ Iran, dealing with persecution of people on the grounds of their sexual orientation, whether they could avoid it by suppressing their sexual identities. And recently, RT Zimbabwe applying the same logic to whether people should be expected to lie about their political affiliations in order to avoid persecution. All those cases are far-reaching in their examination of the human rights paradigm, bringing human rights to bear at the heart of the meaning of persecution for the refugee law. But they stand in glorious isolation unless the facts on which they are based are thoroughly examined and investigated. When the decision of Shah and Islam came out in 1990, there were real concerns that half the women of Asia would be arriving in the UK the following week to claim asylum, because it could be said that gender discrimination and ill treatment of women was pretty widespread through significant numbers of countries and nations. But that didn't actually happen, and very few protection claims were eventually upheld, partly because once you have the legal concept, you then got to drill down to what the position is on the ground. And the people that do that are really the national judges. If you have a concept such as Article 3 of general application, irrespective of the credibility of the individual narrative, or 15C, are you at risk of a generalised violence in a war zone, even though you have to be an individual who is a generalised violence, at risk of generalised violence? The traditional tools of asylum determination, credibility, convention, nexus to a convention reason, etc., real risk, become less important. It's much more about what on earth is going on the ground in country X or Y or Z, and how do you find that out? And how do you come up with it? If we are to have a common UK system, and I'm a UK-wide tribunal, I've flown here this afternoon from Belfast, where I'm sitting until 1 o'clock today, and I sit in Scotland as well. There are a number of asylum centres. There are potentially 600 first-year judges all waiting for guidance from the upper tribunal as to what the approach is. And we're trying to ensure, through a country guidance system, that they have guidance on what is going on, which is up-to-date, effective, thoroughly investigated, fairly investigated, and it enables experts on both sides, if the Home Office want to call any experts, to assist us. Strictly, as a matter of logic, it seems to me, if it's an objective question, is there a real risk that X, simply because he is, for example, a national of Iraq, being returned to Kirkuk or Mosul, or why, because he belongs to Somalia and he's being returned to Mogadishu, is for those reasons alone at real risk of ill treatment, or there are risk of generalized violence as a result of internal armed conflict, then the answer ought really to be the same, whichever judge you're appearing in front of, in whichever tribunal, whether it's Belfast, Glasgow, London, Manchester, Leeds, Southampton, Cardiff, you name it. Country guidance in the United Kingdom is designed to achieve that. But hey, why stop there? These are European concepts which we're applying. And the idea behind the common European asylum system is one bite of the cherry allocated according to the Dublin regulation procedures. So why should a judge in France, or Germany, or Sweden, or Norway, or Greece, or Italy, be coming up with fundamentally different assessments to whether there is a real risk? And how on earth do they do it? Many of our colleagues' European systems are administrative law systems where the initiative lies with the executive decision maker and the judiciary review for rationality, sufficiency of reasons, but don't really look at the raw data themselves. I don't think that's going to work anymore. I think Europe's going to have to abandon that, and they're going to have to get down and look at some facts. This paper, which I'm talking to, and I circulated through the institute, through the school afterwards. I've been working on it for some time. I launched it at a seminar of the International Association of Refugee Law Judges in Warsaw a month ago. I then managed to convene, through my colleague Hugo Story, a meeting of judges of the Strasbourg Court, the National Court, and the Luxembourg Court in Strasbourg last 2 weeks ago. And that's where this paper then got its big air. And it received a considerable degree of interest and support. Because Strasbourg is saying to us, the national judges, unless you intensively examine the conditions in these countries, unless you look at reliable evidence, look at UNHCR guidance, look at other sources of information, country information reports, human rights reports, keep it up to date, keep it informed, and you ask the right questions, and you, the judges, sign off at the end of the day on what you think the picture is. Unless you're asking these questions, you're not doing the job, and you're therefore leaving Strasbourg to issue a Rule 39 request, which stops removal, and in the case of Sufi and Elmi, 4 years of stasis, as meanwhile conditions were changing daily on the ground. Of course, if you get a decision in Strasbourg which takes 4 years to promulgate, it may take 4 years before you decide, well, actually, now the tank has moved from the airport, and the chap with the machine gun that was firing into the heads of the crowd last week may have now moved off and do something else. In fact, he's earning his living as a fisherman. I don't know. So it tends to a bureaucratic inertia. Equally, there are other problems about Strasbourg deciding these issues at the first instance court and the last instance court. It's not subject to appellate review. And as we know at the moment, there is a democratic deficit with Strasbourg. And I think, I don't know what's happening in Parliament at the moment as we speak, but they may be deciding within the next 24 hours whether they're going to follow Strasbourg ruling on the roads with prisoners. There is a bit of a paradox with our present government about Strasbourg, ECHR, and immigration and asylum. On the whole, the major theme of the government is subsidiarity. Strasbourg should confine itself to the important points of principle and not the everyday factual cases which turn upon their own particular points. So Strasbourg should sit as the pinnacle of the judicial pyramid, but it should not likely interfere with national authorities applying Strasbourg criteria. That's fair enough, except when it comes to the topic of Article 8, they apply exactly the opposite. Only Strasbourg knows what it's talking about. The minimum criteria in Strasbourg, the only criteria worth looking at, nothing else should apply. Bit of a problem there. But in this, my topic is not dealing with private life and Article 8 and family life. That's another seminar series for you. which will keep you busy, I'm sure, for many years to come, as I'm sure it will keep the courts busy. My topic is Article 3, and to some extent, what we are doing in the upper tribunal seems to be two delivering goods about subsidiarity, because the Strasbourg judges were happy that if we do what the intensity of scrutiny required by the Strasbourg court into country conditions, then it's likely that the test in Strasbourg will be whether the national authority has sufficiently considered the issues and is their decision adequately supported. I quote that from a case called Al-Hamdani against Bosnia, 2012, the Iraq case, where they decided not to intervene with a negative decision. And that seems to me, at least, to be more appropriate, because a national court can certainly spend longer on examining the facts in Strasbourg. As if any of you have ever been to Strasbourg, you'll know you get an hour to present your case if you're lucky. Whereas if you appear before our tribunal in a country guidance case, you may get a week. If you're very lucky. But that depends upon the case. I hope we can cut it down a little bit shorter than that, but at least there may be live evidence. We've just given another decision on Iraq a few weeks ago. I think we looked at 750 documents. There are vast numbers of paragraphs. We had experts giving evidence. We looked at a wide range of reports. And although one hardly promulgates a decision on an area of conflict without knowing that things will change within months, even days, and that we must always keep the flexibility to accommodate those changes, at least it is now being generated at a more speedier, more efficient level, certainly than the international courts. And of course, we are applying in our country guidance these three sources: the Refugee Convention, the concept of Article 3 risk, and what the Court of Justice tells us is required to make a proper assessment under the Qualification Directive. Luxembourg, as many of you will be aware, it has a different relationship with the National Court. The Qualification Directive, or EU law, it has to be applied, and it's left to the National Court to apply. But if the National Court is in doubt as to what the law means, it can make a reference, an advisory opinion. The Luxembourg Court tells us, sometimes tells us, or purports to tell us perhaps, what the answer to the question we posed is, and then we will apply that in our national system. So Luxembourg is a stage in the national decision-making, whereas Strasbourg follows after the National Court has finished with it and domestic remedies have been exhausted. So that is the broad outline of the problems and the reason why we have developed a system of country guidance. And the government in its other aspects are acknowledged that the system of country guidance is useful and has been winning international respect. Strasbourg will nearly always now refer to an upper tribunal country guidance decision if there is one that's comparatively recent and seems to have done the job. And we are aware now that they will take into account of our country guidance jurisprudence when considering whether a Rule 39 request is appropriate or not. So we are reaching out beyond purely national boundaries simply because we are doing what we think is required to be done according to our different feelings of European law. Having then set out a little bit about how we came about our system. The system started in about 2002. It's been developed and since then, there are a whole lot of practice directions telling people what a country guidance case is and what its effect is. Essentially, it's a case which is reported, put on the upper tribunal website, noted as a CG case, and that means that any immigration judge must take it into account when considering a case of similar sorts from the same country on similar evidence. But taking into account and treating it as authority, which is what this senior president's practice statement says, does not mean it's precedent. But it does mean that it's a starting point for a decision, and then you've got to look at whether there have been material change in circumstances to see whether you ought to depart from the conclusion of the case because of fresh evidence that was not available to the tribunal issuing country guidance. That's the way the system is designed to work. The benefits of the system is that it is intended to promote the administration of justice, because parties in an appeal of first instance will not have to repeat the exercise of vast numbers of documents, numbers of experts, and in every single hearing centre throughout the United Kingdom. Often people may not have a proper legal representation, or legal representation granted at the last moment, and they don't have access to all the best experts that may be available in London, or the best advocates to produce it. So therefore, an effective system of guidance at this level is designed to ensure that inequality of resources is dealt with in the best way, and that there is consistency of decision-making throughout the chambers of the first-tier tribunal and on appeal the upper tribunal. But equally that there is sufficient flexibility in the system so that this is not a set of handcuffs, but guidance, which is what is intended to be. Starting point in the reasoning, it may be the end point if nothing has changed, and then if there are debates as to change, the upper tribunal can designate a fresh case as country guidance, which will examine whether there have been changes. That has frequently been done in the case of Zimbabwe, Somalia, Iraq, Afghanistan, for example, and doubtless that process will continue. Just a few matters of detail then before I take questions. We've had to work reasonably hard to achieve a system which is fair, transparent, efficient and effective. Clearly, country guidance cases tend to be the cases which advocates will seek to take to the Court of Appeal and subject to particular rigorous scrutiny. Well, fair enough. If it's to be guidance, it ought to be effective guidance, and flaws in the reasoning process ought to be examined by the Court of Appeal. But we've also had to persuade the Court of Appeal that they have to move at an appropriate rate, because a delay can be the enemy of justice in this field. And no one really wants to see a repeat of the 4 years of sooner position, certainly not Strasbourg, certainly not the national courts, as it undermines public confidence in the system's ability to get a result fair and fast. And I think by a number of different interactions, that is gradually happening. And just because a country guidance case is going on appeal doesn't necessarily mean everyone from that country can stay here and that it's decided, although it may mean that part of the person affected by it may get interim protection, both at national level and international. Country guidance is not intended to take away judicial discretion in an individual case, because each case ultimately is determined upon the facts of the individual and upon certain changes, particularly in fast-moving countries such as the Somalia example that I've given. Country guidance does, I suggest, enable a principal relationship between the national court and our European courts. And I will indicate what, in my belief, the elements of that principal relationship are and should be. One, the national court must fully and fairly assess the claim, applying the criteria given by the Refugee Convention, the EU Directive, and the ECHR case law. Two, the national court must ensure that the case has been considered on the basis of the most recent and relevant country of origin information, and that the appropriate inferences are drawn from that information. Three, whilst there is obviously scope for flexibility in how the material is assessed. It's not the executive or the administrative decision maker that should take the final view, but the National Court's duty to ensure that there is an effective remedy at the national level to ensure that Article 3 risks are examined all before domestic remedies are exhausted. The test is whether there is a real risk or substantial grounds for risk in the event of expulsion, and not whether a reasonable decision maker is included or not. 4. National procedures must be sufficiently flexible to permit fresh claims to be made and considered, and where credible, where credible fresh material arises, but nevertheless can be examined by the National Court. And suspension measures should exist to ensure that a reasonable chance is afforded to access the courts before any expulsion decision is implemented. It seems to me that anything fit less than the application of these standards is likely to lead Strasbourg to intervene in a case where there is serious argument about risk, and that means decisions will be remade at the international level rather than the national level. However, 6, where the national procedure achieves this level of scrutiny and intensity of scrutiny, then Strasbourg, just as our Supreme Court and our Court of Appeal, should afford an appropriate degree of respect for the National Court's assessment. We are an expert tribunal doing this daily, weekly. Our judges keep informed about developments on the ground and in case law, and they are far more likely to have an informed view of what's going on than a generalist judge sitting even in the most distinguished court. 7, in principle, where there's been a change of circumstances since the National Court last examined it, then Strasbourg ought to require the claimant to exhaust the domestic procedure by making a fresh claim, rather than simply taking over for itself. That's a point of criticism of CCNLB that others have made, that they didn't give sufficient consideration to national procedures, which might have enabled the fresh evidence to be considered at national level, and then the subsidiarity principle. But no doubt a pragmatic view would need to be taken if changes happen on the day of the Strasbourg hearing, bearing in mind it takes long enough to get such a hearing. So those are the principles which I suggest national courts in Europe need to consider and address, and if we do, then that puts the Strasbourg role at the subsidiarity level of the picture rather than a prime decision maker not subject to right of appeal. And I think in that respect its jurisprudence will be enhanced in respect rather than get into the hot water that it sometimes gets into when it appears to adopt the position for the first time without anyone realising how it's got there, why it's got there, what it exactly means. The work of the Strasbourg Court has recently been criticised in an article by a Belgian judge, Mark Bossert. The Strasbourg Court acted as an asylum court, published in the European Constitutional Law Review 2012. I don't share his criticisms. I make plain. I think he's wrong in criticising Strasbourg's incremental jurisprudence on detention and on reception conditions for asylum seekers and on the ability to examine for itself the facts where it's not satisfied that the national procedures have done that. However, I think there is something to be said for his concerns that in certain cases Strasbourg has exceeded its role by being the first and last fact finder rather than reviewing the quality of assessment at the national level. And of course that imposes the challenge for the national judge to meet the criteria, which is a challenge that I hope we rise to in the United Kingdom. And I think that will suffice now to terminate my remarks. There's a whole lot more detail about how we go about these decisions and why we go about them, and one or two other comments on other issues. But I hope that will generate sufficient information for questions and discussion. Thank you very much.
Thank you very much. Okay, as per our usual format, it's really open to the floor now to make comments and suggestions and ask questions of our speaker and of each other. I know in listening to some of the things that Sir Nicholas has been talking about, one really gets the sense that this is where the cutting edge is at the moment in a good deal of asylum law practice. And also in theory, looking around, I know that there are a number of academics and practitioners who are working on precisely these sorts of issues about the interface between international standards, particularly European ones, and how they become implemented within national forums. Talking also about the different loci of legal interpretation, I think it's useful to get a perspective from the bench, which is perhaps one that we don't see often enough within academic circles. And I'm sure that there are a great number of questions that participants here would like to ask. So if you have a question, can you please raise your hand and I'll take them again. Yes, Paul.
I'm Paul Delane. I'm a member of the Refugee Law Department at Amnesty UK.
Paul, can you just speak up?
Sorry, I'm Paul Delane from the Refugee Law Department at Amnesty UK. Obviously at Amnesty we realise that our publications, our research may be relied upon by both sides. We intervene in domestic proceedings in Strasbourg and in Luxembourg, and we also offer country reports in domestic proceedings and have done in 8 country guidance cases to date. I agree, I speak a lot to counterparts in Europe who ask questions about the country guidance mechanism, which is an unusual mechanism in some countries, especially civil law countries. And one of the cases I was involved with, BA Iran, recently the European Court of Human Rights criticised Sweden for its treatment of a subclassed Iranian claim and specifically said to Sweden, look at BA Iran, this is what you should do. I read with interest the country guidance determination last week of the upper tribunal in HM Iraq, where the importance of the mechanism is reaffirmed. The tribunal indicated that in the future there may be highly unusual circumstances where a country guidance case may proceed without a proper contradictor with the appellant's representative, which was obviously a matter for the Court of Appeal after the first Iraq country guidance case. With legal aid reforms next year, it seems likely, if not inevitable, that the numbers of unrepresented asylum-seeking applicants will increase, possibly by large numbers. But some in the refugee law sector may be concerned the idea of a country guidance case without a proper contradictor, to use Mike Ford and QC's term. My question is from an evidentiary perspective, as an organisation that provides country expert opinions, in that I'm not entirely sure what those highly unusual circumstances might be, but I don't think the upper tribunal made that clear. Maybe it's not possible to make that clear at this point. They also mentioned the research facility of the upper tribunal, and they mentioned that in limited circumstances evidence may become available, come to their knowledge. But I don't think that they're saying that the research facility could provide the ability to put in front of the upper tribunal all of that objective evidence that you would expect to see.
Well, it may, but okay.
My final point was on expert evidence, because of course if there is no proper contradictor, and unless the Secretary of State might be persuaded to instruct an expert, then that benefit of expert evidence would not be before the upper tribunal in such a country guidance case, and how you might envisage that might operate in practice.
All right. Would you like to take a few questions?
I think that's probably quite a specific one, which deserves quite a lot of response.
Okay.
Largely which is in the paper, but I'll deal with it now. You, from where you're positioned, you're obviously well informed about the system, and that's helpful. As you know, Robert Thomas reviewed his working with the system. I then asked to have a seminar in which various users came to sort of see what the advantages are. I mean, there are some disadvantages in the system, delay, cost, and things of that sort as well. And sometimes I wonder whether is it exactly precisely doing what it's intended to do, fair, fast, efficient, and disseminating good practice rather than sort of locking in bad. But one of the tensions which I'm conscious of is the tension between an adversarial system and an inquisitorial system. But, Court of Appeal, listen, we are an upper tribunal. We are inquisitorial where we need to be. We prefer, obviously, to sit back and have two elegant QCs, tease it all out, present everything, and then we say, yes, wonderful. That's not reality. It's not the way the system works. And I make sure that I get Court of Appeal judges to come and sit, and they go through that learning curve. I teach them about life. It's like this happens in my tribunal, not in the Court of Appeal, let me assure you. I mean, lovely place, wonderful place, and wonderful preparation. You know, we've got counsel, we've got skeleton arguments, we've got authorities. I mean, you know, I've, as I say, I've been sitting today, and I had to bring the authorities, I had to introduce the issues, I had to raise the arguments for both sides, and then I had to go away and decide which of the two arguments that I raised I think is the better one. And that is what life is like, and we're going to have to get used to that, particularly in an area of immigration where not only do you have this retreat from legal services, but you've obviously got language, you've got skilled people who don't necessarily know every last nuance of the European Union case law, which I do, I hope. And you've got a whole variety of problems. So we simply can't just sit back and sort of say, oh dear, you know, what a shame. And if we are to generate guidance on countries, which is of importance, we need to keep it up to date and fresh. And we therefore have to work to our timetable to some extent rather than the parties. Home Office, from time to time, in the past, I've been told by my colleagues, didn't particularly want a country guidance case because they thought, well, that would be to take it at the height of the risk of protection, and that would then fossilise it, and so they didn't want to play it. And they didn't participate in the notorious case of RN, or RS, the Zimbabwe case. And then they weren't too pleased with the result. I'm afraid there may equally be temptations the other way for a claimant who's set up this case for 6 months, as it sometimes took place. They've got their experts' reports, and they can see they're not going to get the result they want for their client. So what do? You walk away. And you say, well, you can't do that, you've got no interlocutor. Sorry, don't mind. Obviously, we prefer to have advocates. We will have to explore if legal aid cuts has been. I've presided over my time at the upper tribunal to see both the RLC and then the UKIS go, and that's extremely serious and extremely sad. Centres of excellence that could assist us, you know, one tends to turn in relief to advocates who can help clients and can help the tribunal. But if that's the landscape in which things develop, we will have to do our best. We are, no one claim omnipotence about facts, obviously. Facts are facts. But in each amnesty report is circulated within a week, or its existence is circulated within a week to all judges on our weekly email updater. It will be noted on our monthly legal research bulletin, and it will be discussed by the conveners of the country guidance case. I don't necessarily agree with everything you say, but the existence of the report is there. Equally, UNHCR guidelines, which are given particular prominence in Strasbourg. Mr. Bosley doesn't like that, but I think Strasbourg made it plain, and we will do what's called for. So if a repeat of HM Iraq, Mark 1, came about, we'd have to see whether what the issues were and whether we're sufficiently appreciated. As I say, I ran this paper with my European colleagues in Strasbourg, Harold Dorring from the German Higher Administrative Court said, advocates, oh, we don't need those. Get them away. We are truly inquisitorial. We don't either wait for the advocates to come up with a point, or we need them to tell us what the point is. And I said, oh, perhaps you want to come along and give Court of Appeal lectures about how they do it in Europe. But there's clearly a balance. One that, we're feeling our way in a world where the adversarial system, if it's properly developed, properly funded, is a wonderful luxury. But we're not all driving Rolls Royces. We're now trying to find the rusty wheel on the spare bicycle. But we've got to deliver the job for the people who need the answers to their cases, and we've got to do it. And so that's how we work.
Thank you. Is this a follow-up?
Well, different point.
Okay, yeah.
Sorry, so Nick, I was interested that you concentrated on Strasbourg, but of course from November 2013, the recast of the Qualification Directive is going to be implemented in the EU member states, apart from, of course, the UK, Ireland and Denmark. And what we now have with the recast of the Qualification Directive is common standards rather than minimum standards. And if you look at the recent case of Y and Z, in September 2012 on the Amadi situation and discretion, and the impending case on X, Y and Z in relation to sexual identity, it's going to be very much based on country conditions and country evidence. So do you feel that now with the two-track qualification directive, where the rest of Europe will be going on common standards, and the UK, in my view, quite rightly, is looking at minimum standards, there'll be a schism between the two scenarios? Now, I've got a separate question, if I can also ask, in relation to country guidance lists and updating of lists. As far as I can see as a practitioner, the Tribunal only strikes down their own country guidance lists if there's been an order by the Court of Appeal. In the case of example, or another higher court, where a case has now been considered no longer to be in force, for example, the recent case of EM Zimbabwe a couple of months ago, and then other cases therein. In case of in case of Uganda, JM Uganda, a case which I was involved in 2007, which got the court in 2008, is still on the country guidance list, even though in February 2010, the administrative court in a case called SB Uganda said that JM Uganda cannot be quite properly relied on as a post-datum country evidence. But more importantly, and this is an interesting development, and I'd like to see what your comments are, even the Home Office operational guidance note now accepts that gay men and lesbians suffer harm in Uganda. So what are the control mechanisms within the upper tribunal to review the country guidance list when either there are authorities which supersede it, post-dated, but may not actually have an order which strikes down the specific country guidance case, or there's a change of internal policy by the Secretary of State in relation to that? Because the problem I find with determinations is that when individuals don't know about these changes of policy, individuals are losing their asylum claim because judges are relying on the country guidance case.
Well, it's published our approach to changing country guidance, and it will remain unless and until replaced by a fresh country guidance or reversed by a decision. Where country guidance become outdated by developments in question, it's anticipated that the judge will have such credible evidence, such as an operational guidance note, and then will say that this means that I now have to move on from a position in the country guidance case. There was a debate about this in the seminar, and I particularly wanted to listen to the different views. There was one view that after 5 years all cases should sort of lose their sell-by date, but that view was considered to be too bureaucratic, and that if there are cases coming through and things happen, then they will change as they come through. And so if there is new changes, then that will reflect what's going on. And that's how the country guidance gets updated. It's difficult, otherwise the designation of a country guidance case and the redesignation becomes almost a judicial decision. And judicial decisions are decided by judges hearing cases, not by judges sitting in an administrative session in a committee meeting. It's appropriate that that's that way. But I wanted to stress, and I have stressed, both in this paper and in my learning, when you read my judgments on the question, one or two to come, which I have to wait for, that it is guidance and it's a starting point, but no more than that. And anything, I reject the term that Lord Justice Lawes applied to it, a factual precedent. I reject specifically in this paper, which is now on the judicial register, for that purpose.
And could I ask you to address the point about common standards as opposed to minimums, if you're able to?
Yes. Yes. Well, yes, I note. I tend to think at the moment that it's better to have minimum standards than harmonised standards. Though that might change. Everyone I've spoken to, my European colleagues, thinks it'll make no difference, but I'm not entirely sure. We raised in session with our fellow judges in Strasbourg the view that the community competence in this is predicated on the primacy of the Refugee Convention. And I think that if that's right, I can't see how the European Union can ever say you must change your national case on refugee law because you're too generous to refugees in interpretation of it, whether it's about sexual orientation or some other topic, I don't know, bad faith. Theoplast demonstrations outside the Iranian embassy might be an example, in particular. So I don't see how that can apply, but and I do think Luxembourg will need to be informed of this in particular cases as we go along. I'm pleased that we've started a conversation, and the conversation will continue. But as to how Luxembourg will apply it in 2013 and thereafter, I can't say. In substance, there's not vast amounts of difference between the two directives at the moment. It's simply the concept of it. I hope that the Supreme Court is sitting on an exclusion clause case, which might possibly say something about the privacy or otherwise the Refugee Convention. We'll wait and find out. But I think I tend to agree that subsidiarity means minimum standards which you ought to apply rather than maximum standards. See the earlier comments I made.
Thank you very much. Further questions? Yes, Dr. Stone.
Thank you very much for your very interesting presentation. My name is Rebecca Stern. I'm from the University of Uppsala, Sweden, and we're faculty by the RC case. I'm also visiting fellow here at the Refugee Initiative. I was wondering, when you decide on the country guidance cases, how much do you look to other national courts for inspiration or for look at what they have said regarding the country on which the case is supposed to be or on which the decision is supposed to be? I'm also wondering if you look at the decisions from the UN treaty monitoring bodies individual cases, and if that also has an impact on the decisions on country guidance cases.
Yes. If we're aware of a fellow court, and it's usually going to be in the European community of judges, are grappling with the case, we will try to exchange information. A number of people who passed through the field house the last 2 months. I've had the French Senate, we've got German judges next week, I've got Norwegian colleagues from Norway coming the week after, and Polish judges, Dutch judges. So there's quite a lot of, one of the interesting parts of my job actually is this European exchange. And the International Association of Refugee Law Judges is also a vehicle for exchange of information. And of course, no national system has a monopoly of virtue. In the Sufi and Elmi case itself, Strasbourg noted a Swedish case, which was giving better protection than the AIT had done in an earlier case. So there's always that discussion. It's just that where certain of the civil law systems don't seem to have, and I discussed this with the judge of this higher administrative court in Poland, their view is if there's a flaw, you send it back to the decision maker rather than remake the decision for yourself. And it's the remaking powers the upper tribunal has, which has given us this ability to progress the system. So we do look at other national systems, and we particularly look at the reasoning. I think when I did the HM case, which we made it, we were aware of Bulgaria to come up with a decision and one or two others. But for us, it's the quality of the reasoning rather than the decision. And certain civil law system decisions are simply glorious little preambles, and then saying, and you win or you lose. Did I miss the reasoning why? And that's what one wants, particularly when it's about evaluation of country cases. UN monitoring systems, that is a source. I can't say that the judges will themselves go through the database, because otherwise you wouldn't be able to get on with the rest of the job. The job is challenging enough as just the moment. There are one or two famous decisions, and of course it could be said, particularly I think in respect of Sweden, that used to be in the doghouse with the CAT at one stage, said you're too credibility orientated rather than real risk. And I think, but now I think you will find that Strasbourg is pretty alert to those developments, which is why I think if you look at the more recent body of Strasbourg cases, that they are stressing approach to credibility, approach to documentation, and I think they will tend to pick up the approach. I mean, I tended to have found when I was at the bar and I looked at these things myself, some of the CAT decisions, if they weren't the breakthrough cases into certain areas because no one else was monitoring the country because they were outside the European experience, some of them may be quite circumscribed in their reasoning, and that's therefore going to be limited value. What you really want to know is what does X and Y and Z think about what's going to happen tomorrow in Harare Airport, or on the route from Harare to the low density or the high density townships outside, and who's kicking who at the moment, and why, and what's going on, or is anyone kicking anyone, or that kind of stuff. It would be comparatively rare for a CAT decision to drill down to that level of detail, but of course you can get some principles, and principles I think are now going into this human rights jurisprudence which informs all this, why these three sources of data which makes it a particularly interesting job. Yeah, exhausting job at times, but
yes, Professor Manley.
Yeah, Steve Miley from the University of Minnesota Law School. Thank you for your comments. A couple of questions. The first is whether or not there's a hierarchy of expert opinions that's developed over time. In the States, of course, we don't have a country guidance system, but certainly country conditions play into the determination of whether or not someone has a viable claim under the Refugee Convention. And what's evolved there is that judges will rely predominantly on U.S. State Department reports, and much less so on other expert reports, Amnesty, et cetera. And I don't know if something has evolved here, but I appreciate your comments on it. And then the other question stems from your comment that because of Article 3 and 15C, what's going on in Country X is more important than Refugee Convention factors and credibility. And if that's taken to its logical extreme, could you have, or perhaps illogical extreme, could you have a situation where someone just says, I'm from Country X and therefore entitled to protection? And if that's true, does that have the impact of making judges who are deciding a country guidance case particularly cautious because they're concerned perhaps about the floodgates effect that you alluded to? Because then in subsequent cases, all one applicant would theoretically have to prove that they were from Country X.
Yeah. Right. Experts first. As a matter of practical reality, I think if the UNHCR has come up with some recent detailed country assessment risk factors, that is probably considered to be the most important data. And Strasbourg says so, and gives particular weight to that data. Caveat. Helpful as these guidelines can be, if, for example, and I'm not sure that my colleagues have grappled with this in the recent HMR Mark II, but I mean, I know the problem that the recent May 2012 UNHCR guidelines, magnificent, followed page after page after page, region by region, risk category by risk category, religion, ethnicity, gender, etc., etc., etc. And then particular risks, who are the agents of persecution, who's doing what. And so you're getting a lot of data and saying, once you get 2 or 3 risk categories building up, you know, watch this space. But then you see, after all this, a little grey box and saying, therefore, we consider anyone from an area may well be at risk of needed protection, which means, well, if you said that from the starting point, then I needed to have read the first 76 pages of this guidance. And so I said, you can't really mean that. I've been able to debate this with you in ECHR direct, and so in a private session, so I won't say more about it. But that's an example. And obviously, an Amnesty International and others will be looking to protect all those who might fall within with a class of case. That's perfectly understandable. Anyone whose mission is a human rights assessment will be looking for that. But as Strasbourg itself has said, in the Al-Hamdani case, UNHCR guidelines might themselves, for other reasons, not to clog the country's social capacities at a time when return is happening, but it doesn't want to happen too fast. Or there are politics, and politics in Zimbabwe is something which we have to work our way through, or the politics between UK government and Zimbabwe about returns is certainly a factor. How much of a factor, we're going to work it out in the individual case. Expert evidence, I think that's you actually asked that question, I didn't actually address it. Again, a bit like adversarial procedure, wouldn't it be nice to have 2 experts battling it out in the witness box? And then you'd say, I prefer X and prefer Y. That doesn't tend to happen. Home Office wrote to us after the seminar, the user seminar, following Robert Thomas's report on the country guidance, saying they see particular reasons why they can't instruct experts in country cases. They assume that would undermine diplomatic relations with certain countries, because they seem to be endorsing that. Obviously, they're the experts on foreign affairs, and not me, and I have to give certain weight to that. So they will tend to do their country of origin information policies, which may be up-to-date, accurate, and effective, or may not. And sometimes the operational guidance notes, which we don't rely upon as country guidance, but we do note as country assessments. So, in fact, in answer to another one of your questions, I'm not suggesting everything is perfect in every case, pleased to hear. I'm aware that the Sudan case was reversed as country guidance when the operational guidance note came out. Yeah. And simply on the operational guidance note, I was pleased that was the case for reasons which I won't go into. But and so that's the way it tends to happen. So we don't tend to have 2 experts, and therefore the Home Office take the risk that if an expert A is persuasive in assessment, all they can do is cross-examine that expert and see if they can look at gaps. I would say my personal experience is limited. I think my other colleagues have got more experience of seeing what experts can reply. To some extent, in certain areas of the world, you will know who the experts are. In some sense, you will know what their views are. Their views sometimes remain the same, despite what one says about it. So there are limits. And of course, there are challenges between turning a general human rights critique of a country, which is a perfectly acceptable part of a human rights organisation, which doesn't always read out into a protection criteria. So we're realising we're not conducting an international foreign policy debate about whether country X wins the desirable place to live award for 2012. We are looking at criteria for protection. Yes, there are countries, and I think probably Somalia is the key country, really, since where it could be said, and it has been said, that the conditions are so generically bad, particularly if you can only feasible route of return is to one area, Mogadishu, ignoring northern Somalia, and that is in the hands of gangsters, cowboys, terrorists, whoever they may be at the time, that you simply can't return people. That does mean that the stakes become quite high, and that's why a lot of people who didn't come from Somalia then claim to be from Somalia, even though they probably come from northern Kenya or something of that sort. Just as you know, shortly after HJ Iran came out, we heard a rumour going around that there was a message going around at Harmondsworth Detention Centre that if any claimant asked for a condom, they could use this as evidence of their sexuality in order to make a relaunch a case. And a lot of people who tell us a lot about their private life in the past suddenly had a rapid shift when they realised this may be of advantage to them, sometimes in the right circumstances. I mean, and that's credibility assessments. That's part of that. So there are credibility assessments as to whether you've come from country X and country Y. And clearly it makes the judges anxious to examine whether it really is true that no one can be returned. And that's precisely what was going on in the Somali cases, Sufi, Nelmi and AMN. And even if it's true today, it may not be true tomorrow, and things do change. And so that's where you're going to get the internal relocation jurisprudence or sufficiency of protection issues, and say, yes, it's not a very nice place, but there may be other solutions to international protection. And of course, sometimes the nightmare of the refugee lawyer or the refugee judge is you think generous protection in the West is the equivalent of ethnic cleansing in the place where the people come from, and you're simply encouraging the persecutory state to get rid of all its people he wants to get rid of because you're taking them all in, and then they say, oh, we can now be the pure X, Y, or Z state we always wanted to be, rather than the polyvalent, democratic, human rights respecting community that you know.
Okay, I think we've probably got time for one final question.
Thank you, Justice Bennett. One question relating to your historical approach to country guidance in the Upper Tribunal, going back to 2002. So it's a system which seems to have built on and originated in Refugee Convention cases, mostly. And now that you have Article 15C, which really doesn't look at persecution, but rather serious harm in the sense of intensity of violence, level of violence in an area of conflict. Do you think the tribunal is going to approach country guidance slightly differently with regards to 15C? Is there perhaps an opportunity or a call for separating or trying to gather different kind of information than what we used to on the pure refugee convention cases? And I'm thinking in terms of how to provide evidence that a particular individual or group of individuals fear a certain level of violence as required under Refugee and Article 15C. How do you provide evidence that a particular area of armed conflict reaches that level of violence? Is there new elements that needs to be considered into country guidance reports?
Well, I mean, that's, I suppose, it's the task that I embarked upon in the autumn of 2010 with the Iraq situation. Yeah. It was entirely based on that we had a group of young men who had nothing else about their cases were accepted apart from the fact they came to the north of Iraq. And so we had to sort of drill down to whether that factor alone would put you at risk in the particular circumstances. Now, Iraq, for various reasons, is quite rich in various NGOs documenting the level of violence. The Iraq body count, there are other surveys, the Brookings Institute, a lot of the US institutes were actually doing work about it all. Sometimes the data, the task, I think, for the judge is to see, does all the data, when accumulating, point the same way, or are there big conflicts? And if there are big conflicts, which do you prefer? If you can't be sure what you prefer, you're looking at the core concept of risk rather than proof or truth. So I do think that 15C and equivalent Article 3 generalised protection, Somalia, Sri Lanka, Afghanistan, Iraq, these are the countries that keep coming up. Sudan, perhaps less than that, a few years ago certainly was true, does require this you to be alert to all sorts of information, but it's the best information is sourced information, and then you want to pursue what's going. I mean, even though we have an inquisitorial role, we can call for it. We can bring into the debate material that we're aware of as judges, and material that we circulated and have noticed in existence if the applicant or the appellant doesn't do that, and that would include operational guidance, I'm sure. Obviously, there's other material that may be researched upon by somebody somewhere which is not in the public domain, or unless it does, we won't know about it. So we're open to the material if it's appropriate, and indeed. I think the question would be what limits we put upon it. Otherwise, you can spend 6 months looking at a perfect analysis of what happened yesterday, and then finding that it's a waste of time because it's out of date. And so there has to be some balance between intensity of the scrutiny, the investigation into these conditions, and the adjudication upon what risk and protection issues that material gives rise to. And trying to achieve that balance and avoiding delay, avoiding an inappropriate degree of technical scrutiny, which occasionally includes QCs and other things. But getting down to the job is what we're trying to do. So I think it probably has changed, but I think country guidance in reality works best when it's looking at country conditions rather than an evaluation of assessment of refugee status. I think those are just decisions.
Good. Well, thank you very much to you all for a very wide range of questions and some very thoughtful responses from you, Sir Nicholas. I'd like you to join me in once again just in thanking Sir Nicholas for joining us here this evening, and wish you all a very good evening.